Doing this press record. Fabulous. Good morning, everyone. Welcome to Nellie on the Sofa. It's the April edition. We've got Kirsty Findlay with us today. We're going to be talking about safeguarding, and it's going to be interesting. No, it will. Safeguarding for deputies, for not just for deputies, really, is it? For professionals in general, really. So I'm going to ask Kirsty to not just explain who she is, but can you also explain because you're an independent social worker, aren't you now?
We both are.
Yes, and you've gone private. Good for you. But you are completely so far away from what Nellie Supports does. I think it's really important that people understand who you are and what it is you actually do. So do you want to explain a little bit about who you are and what on the file?
Beyond the file.
I knew there was an on. Beyond the file, your company does.
Yeah. Okay. So, oh God, where to start? I don't want to. It feels really awkward in British. When you have to talk about yourself, you just kind of go, ugh. But I'll try my best. Yeah.
So when did you qualify?
Okay. So, I qualified as a social worker in 2017. But my first degree was in law. So I did law and politics initially. Did the legal practice course. And was, wanted to qualify as a solicitor. So I actually worked in legal in the local authority in adult social care law. So that was kind of back in the 2000s. But then I met my husband, who was then my boyfriend, and he got offered a job in America. So we did long distance, so I quit my job and moved over to America with him. So I did do that. So I kind of left the law at that point and was in America for a few years. And then when we came back, because I had wanted to qualify, but because it'd been so long since I'd done the legal practice course, I thought, what am I going to do with my life? So retrained as a social worker, went back to uni, did my master's in social work.
Wow.
Finished that in 2017. So yeah.
I'll be honest, I'm surprised that you were allowed to leave America. That's a bit that I was amazed by.
This was pre-Trump. So,
yeah, there was pre.
No, I wouldn't be allowed back in.
I genuinely, with my tattoos, I'm not going to the US until they've got a new president. I could end up in a prison somewhere, I think.
Hopefully it won't take too long.
So you've got experience with legislation as well, which I kind of assume that means that's why it lends to beyond the file and what you do there, because this is quite heavy duty stuff that you do, isn't it?
I don't know, I just really like safeguard things, so I think it's really interesting. So I guess I qualified in 2017. I'll try and make this really brief. Then my sort of practical social work background was mainly in forensic social work with children and adults. So
explain forensic social work, because there's two different meanings. So forensic is the application of one subject to the law, but that's kind of forensic social work.
I think it's the interface between social work and criminal justice frameworks. So I worked in CAMS, harmful sexual behaviours. So it's kind of therapeutic intervention with young people displaying harmful sexual behaviours. Youth offending. So, that was the youth justice kind of arena. And then I also worked in criminal justice liaison and diversion. So I was kind of doing mental health assessments of people in police custody and going through the court, so Magistrates Court, Crown Court. So I did that for a few years, and then I spent 5 years as a senior safeguarding, public protection and mental capacity practitioner, which is a ridiculously long job title.
Fabulous job title.
It's a pain. You can't fit it on your badge or anything. In a NHS mental health trust. So that was more of a corporate role, so moving away from frontline practice to advising frontline practitioners and services on kind of complex safeguarding and mental capacity cases, so providing advice, support and escalation to them for those, really kind of the coalface end of that real complexity in those things, which I really liked. I also chaired MARAC in that capacity, so there's so many acronyms, Multi-Agency Risk Assessment Conference. So the multi-agency arena where high-risk domestic abuse cases are heard, so I used to chair that as well. But then last year, I kind of transitioned out of statutory services into independent practice. So I set up my company called Beyond the File. I sort of set that up with my sort of former colleague from the NHS and safeguarding as well, called Becca. She's a mental health nurse. So we're kind of quite proud that we've set up a sort of independent multidisciplinary practice. But the sort of core function of that is essentially chairing and authoring statutory reviews.
And that's where it starts to sound heavy duty to me, because you have to be registered. Right, there's actually a couple of things I want to pick up on what you said. Firstly, we need to get Kirsty back on so me and her can talk about children that display sexually harmful behaviour. That was my first dip into social care, working with children that display sexually harmful behaviour. And it's, I think, something that can be very easily dismissed by professionals and families, and very easily misconstrued as well. I think children that display sexually harmful behaviour, because I know with children, and I know we're going off the topic, but it genuinely picked me, with children that display sexually harmful behaviour, if they get support, they don't go on to be abusers. The recidivism rate is so low, it's ridiculous. But the chances of them being labelled as sexual abusers is so high that if they then don't get that help and they're labelled with it, they then have a higher risk of going on to be abusers. And it's not fair, and it's not right. And it's all down to a little bit of ignorance, professional ignorance, and poor management, I suppose. So we need to get Kirsty back on, just so we can do sexually harmful behaviour with children, because it's an old passion. The other thing was about MARAC.
Yes.
So I know we're going to be talking about domestic violence, so I just wanted you to explain a little bit, just what is MARAC?
Yeah, okay. So MARACs, every local authority in England should have a MARAC, multi-agency risk assessment conference. The kind of thresholds and the criteria for referring in can vary, because it's actually not a statutory, it's not got a statutory footing, although a lot of people argue that it should have, really, equivalent to MAPA having that, which is multi-agency flood protection. So it doesn't
have to have a set way of happening.
It's not statutory, but I think we'll see. You have domestic abuse related death reviews are enshrined in law, so MARAC not being as, watch this space, I guess. There's lots of people that think it should be.
It's not statutory, but there isn't, and it has to happen because there isn't another way of managing it.
Yeah. So every local authority area should have its own MARAC set up. So essentially, it will be regularly heard. There'll be a team. So it's multi-agency essentially. So you'll have somebody usually from one of the statutory agencies chairing it, and then everybody should, everyone attends. It's a really good example of multi-agency working, actually, because you'll have police, probation, all the different health services, so mental health, physical health, acute, hospital trusts, drug and alcohol services, domestic abuse services, housing. There should be representation from all those agencies in that area. And then the way of referring in, I can talk about, in the area I worked in, whenever anyone had any concerns about domestic abuse or someone they're working with, they'd complete a risk assessment called a DASH, which is domestic abuse, stalking and harassment. Although in some areas I think they use DARA, which is a different type, but they're both risk assessments for domestic abuse. Complete that assessment, and if that risk assessment indicates that person's at high risk, we're talking about kind of high risk of serious injury, which could be physical or psychological or death, then they could refer into MARAC. There's kind of a bit more to it, so it could be visible high risk, as in the score's high, or you could do it looking at escalation, so actually the trajectory, I've done a couple of dashes and the risk's escalating quite rapidly, or on professional judgment. So you might do a dash and the score from the dash is low, but actually using your professional judgment, what you know about the case and the situation.
Practice wisdom.
Yeah, she could still, so there was a one-off incident where somebody, poured boiling water over the panel while they were asleep, but a lot of other things they weren't saying that were happening. I'm not saying that they weren't, they just weren't telling you that. A dash could potentially score not that high, but quite clearly, that's significant.
You can see what's going to.
Yeah, that still needs referred in. So they get referred in, and then the case is heard. So whoever referred it in will kind of present that case. So what they know, why they've referred it in, what they know of the victim, the perpetrator, if there's any children involved or any of the vulnerable adults, and like all agencies will go around and share information, and then it's kind of up to everybody, kind of facilitated by the chair, to come up with a combined sort of safety plan, I guess. So what can we do to support and safeguard the victim or children? Is there anything we can do to disrupt the perpetrator? But also, does the perpetrator have any unmet needs? Because a lot of people who perpetrate domestic abuse also have their own vulnerabilities.
And if we can meet those,
yeah, it might reduce abuse. But it's really rapid pace. So each case, I mean, in the area I did it in, got 20 minutes per case, which is not a lot of time to share all the information, go around everybody and come up with a plan. But just in terms of the prevalence of domestic abuse, I know...
But I suppose it's sharing of that information though, isn't it? Because if the police are unaware of that household having those difficulties, all of a sudden they are aware. So if they're called to that residency, or if they're driving past that residency, it's sort of on everyone's mind a little bit, even if there isn't a perfect plan in place.
Well, they can add risk markers to that address as a result of being at MARAC, so that if there is a call from that address, they can respond, at a higher level because they're aware of all the information. There's lots. We could have a whole conversation about MARAC, to be honest.
I think it's interesting for the deputies to be able, and for everyone to be able to understand this is a process that happens with domestic violence. That it's not just because if you read the Daily Mail or the Telegraph or any of those sorts of or the Sun or any tabloid newspaper, the only stories that you ever hear is when everything goes terribly wrong and social workers, local authority, police, whoever it is, haven't done their job. But actually 9 times out of 10 they've always gone through a set process. They've always gone through MARACs and things like that. But the newspapers are never going to start reporting that family was put to MARAC and explaining to everyone what MARAC is and everything else. Yeah,
I think there's a lot that goes on behind the scenes that's not necessarily what people always see. But in terms of sort of prevalence, I know in the area where I was a MARAC chair, it was basically the conferences were every week on a Wednesday and Thursday all day. So you'd be hearing kind of on average like 15, 16 cases. 2 days a week, and that was just in one county. So every week that's kind of 30 odd people plus the children that have been deemed by a professional to be at high risk of serious injury or death. So it's just the prevalence is quite shocking if you think of it in that respect. So it's happens a lot.
So unfortunately, beyond the file and what you do comes in after that.
So there's different types of statutory safeguarding reviews. So you have safeguarding adult reviews, and there's different legislation for the different types of statutory reviews. So under the Care Act, it's section 44. If an adult with care and support needs dies as a result of abuse or neglect, or there's evidence to show that the multi-agency could have worked better, I guess, to prevent that, then that area's Safeguarding Adults Board has to commission an independent person to conduct a review of that case to look at, recommendations, I guess, to improve future practice. And then you have an equivalent for they're called domestic abuse related death reviews, or DADAs, although I think that's a bit of a silly acronym to say, DADA. Or domestic homicide reviews. So the legislation and the statutory guidance refers to DHR, so domestic homicide reviews. But there's kind of been other things that have been published to sort of transition the name to domestic abuse related death reviews, kind of recognising that although sometimes people are killed, so there's homicide, and domestic violence was a factor, so that they were murdered by an intimate partner, current or former, or a family member. It also recognises that a lot of people take their own lives as a result of domestic abuse. So it's not just homicides, it's also domestic abuse related suicides. But again, that triggers a statutory review process, and the whole point is looking at
Right, sorry, you've just made me think. Am I right? A guy's just been charged with, I don't know whether it was murder, he's just been charged for the death of his wife, who took her own life.
Yeah, I think it's a Scottish case.
Is it a Scottish case based on the fact that it was his abuse that led
control.
to her?
Yes, and that's going to be really interesting because I think at the moment the kind of legal options open to the police and the CPS in terms of charging, there is some options to sort of charge somebody, but there isn't a sort of standalone offence at the moment of like causing someone's death due to domestic abuse. So again, I could talk about this for a whole thing. It's hard, the evidence threshold that's needed to sort of be able to charge someone with something related to the a suicide is quite tricky. But because of this case, I think, and it's going to be interesting to see what
it could be
happens.
a turning point, a turning case.
So again, the whole point of that is to understand what happened in that case, but applying it to the system. So not just looking at what went wrong in this case. It's like, what does this tell us about how the system responds to domestic abuse, coercive control, like the specific factors in that case, and making recommendations again to improve practice to hopefully prevent future deaths. And then the other type of statutory review is child safeguarding practice reviews, so they're CSPRs. And again, it's a similar sort of thing. It's kind of looking at where a child's died as a result of abuse or neglect, or I guess kind of sometimes near misses can come under the scope of that as well. Kind of looking at learning. The process is a little bit different because you can have rapid reviews, which are just kind of done within that local authority area by the partnership. But sometimes they all meet the criteria where actually we need someone external to come in and build on that rapid review. And
so is it always somebody external that comes and does the reviews? Because as soon as you're saying it, that is that if the local authority do the review, is that not local authority? Investigating yourself.
I mean, I guess you can, because there's different types of training you can do to do these different types of reviews. So I've done the Home Office Commissioned DHR chair training that's delivered by a charity called AFTER, that's Advocacy After Fatal Domestic Abuse. And I've also done SCI, so Social Care Institute of Excellence, is our reviewer training programme. So, sort of done specific training in conducting these reviews. So some local authority areas might get partners trained up on some of these things internally so they can conduct the reviews. And I think, because there is a cost to this, sometimes that might be a way of being able to save costs. But I would say definitely if you're going to get a partner to be doing a review, they need to not have been involved in that specific case.
Oh God,
because otherwise, the independence element
is non-existent.
So I think local authorities can decide how they want to do things, but I do think a lot of the times it is somebody independent that's commissioned, that's not connected to that area or the agencies in that area, to kind of come in with a fresh pair of eyes that doesn't know that way of working in that area, to really kind of ask questions and explore and just be curious about why are things operating in that way. Could we do things differently? And thinking,
what lessons can we learn?
I know, and people sometimes roll their eyes about that, like lessons to be learned. And I know there's sometimes the same things come up.
Is this just a case of the media putting that? Because it's a great line, isn't it? Lessons will be learned, and it's become that eye-rolling moment. So the media put that out to make us all roll our eyes and go, "Oh, they're still not doing anything." But that's not true, is it? Every time something terrible happens, local authorities do change. The NHS does change the way it works. It has to. It's just that there's always going to be vulnerable people that are killed, just as much as there are non-vulnerable people that are killed. But we do learn from it. We do change.
Yeah.
It's just you can't.
It's difficult sometimes.
Remove all risk, can you?
And you can't. You haven't got a crystal ball. And also, a lot of times, the people that commit these offences, there are, there's things like disguised compliance or professional grooming. There's lots of things that go on that make it harder for professionals to really know what's happening. But yeah, I mean, there's banks, for safeguarding acts reviews, domestic homicide. Well, for all the reviews, you can look at, there are banks of all the published reviews that have gone on before, and you can kind of search for themes and things like that. And there are things that come up quite a lot, like multi-agency, information sharing, professional curiosity, all these sorts of things. So there are repeat things that come up. But I guess, and I think that sometimes people have a bit of a criticism of conducting these reviews, and that it would be better to plough that money into frontline services rather than doing these reviews that come up with the same things. I mean, that's something that someone said to me before, and I do totally empathise with that point. I agree there should be more investment in frontline services, but I guess what I wouldn't say is that that and conducting reviews should be mutually exclusive, because if you're ploughing more money into frontline services but you're not thinking from a continuous improvement perspective of, well, we need to know what we need to tweak and get better, then you just plough more money into systems that potentially aren't as foolproof as they could be. not that anything can be fully foolproof. So I think it needs to be a bit of both, really. But sometimes with the reviews, I think there might be a bit of pressure to come up with like that magic wand where if we just change this one thing, we'll completely reinvent this thing, everything will be better. We are constrained by, national government, what things that they set, budgets and stuff like that. But within those constraints, sometimes it doesn't always have to be a big magic wand thing, like little tweaks. As long as we're always trying to aim to move towards making things better, either by massive bounds or like kind of tiny steps, all those things are important and meaningful.
I think, I mean, as you were talking, I was thinking about, I hate talking about this case. There was a child, I think it was only last year, in Skegness, who passed away.
Yes.
Dad had had a heart attack, and the child was left and too young to be able to contact for help. They were under social services, and the social worker did attend, but there was no response at the door. We're social workers, we don't carry warrant cards, we can't kick down doors, even though as a very naive college student I became a social worker thinking that that's exactly what social workers did. I watched that episode of EastEnders where he kicked down the door and threatened to take her baby away next time I visit. But the truth is that we have social workers, local authorities have, I called it once at university, powerless power. It's perceived power. We don't, unless you're an AMP, you have no authority to kick down somebody's door or to even remove a child. Social workers don't remove children. The courts remove a child. They're the ones that put out the court order. In that specific case, I can't imagine. I cannot think of a practical way, because there would have been a serious case review over that. What could you have done differently? Kick down the door? Shouted through a letterbox? I don't think there's a great deal. And those things like that, those terrible incidents, we can learn lessons from it. But there isn't going to be a huge leap forward, like you said, where all of a sudden that changes everything, unless we start putting monitors onto every child throughout the country so somebody can monitor their health throughout the day, which is never ever going to happen.
No. There was a review, that's Bronson Battersby. It's in the public domain, so I think it's important, where we can sort of pay tribute to these people that these happen to, and the lessons that we can learn from that. But even, in that sort of situation, and it was really nice to see reported that the social worker actually was really persistent and did a good job in that case. And you don't often see that in media reporting. Sometimes it's about things like in those sort of situations, or when, how can we improve communication between agencies? There's things that come, even little things that come out that are actually really helpful, but not big things. It's like, live documents, like we'll create a sway sort of place where we'll keep updated the contact numbers of the practice supervisors for all the different teams, but all other agencies can access that, so they can actually see how to get to the right team, because sometimes going through the customer services centres can be difficult. So actually to just improve that, knowing who to go to and easily accessing that information, that's not a big piece of work, but actually the impact of that for other agencies that are trying to work in that way is is still really helpful.
I think that's the thing, isn't it? When we say that lessons will be learned, they have been. They're just very small, tiny little changes that have huge impacts, but they're not a massive policy that is going to be put out. Like we're going to put health management tags onto all children, and that will solve all these problems. Because those big things are possibly just utterly ridiculous, and it's never going to happen. But those small little changes do have an impact and do stop other children and other adults being harmed. Let's
talk about another one that a review I was involved in, which was it was a domestic computer-related death review, but it was relating to care leavers as well, and quite often for those, I think this is quite pertinent at the moment because the government's just announced it's going to do a review into the deaths of young people who were care experienced, because the numbers of people that are either dying or by suicide that are care leavers disproportionately high. So there's going to be.
So these are children looked after children.
Yeah, at the point that they're leaving care. Actually, some of the times, because of the past experiences or mistrust of agencies, quite often the leaving care worker might be the person that they've got the best relationship with. But the review that I was involved in, they weren't kind of automatically invited to MARACs for cases where they were involved because they weren't a statutory partner. So just thinking about that, part of the process of, holding MARACs, it got changed so that if that either the victim or the perpetrator has a leaving care worker, they're now invited, whereas they wouldn't have been before, and that's made a massive difference to the quality of information that's shared. And even just at an agency level, the agency I worked for didn't have, you have alerts on system, like safeguarding alerts.
Yeah.
We didn't have a leaving care alert. But actually, if you're working with somebody and you want to share information sort of appropriately,
that title gives you a huge amount of insight into how vulnerable that person could be. Could be, not necessarily always, but could be.
Yeah.
But if you're not aware of they've just left care or they're in the process of leaving care.
Yeah, exactly. So even things at an agency level of like, well, what we're going to do? We're going to ask clinical systems to create an alert to identify this person's got leaving care status, and actually they're going to have a worker that person can then link up with and sort of share information if there's safeguarding concerns. And again, that's not necessarily a big, we're going to entirely transform a service. No. But these things, you can see how they're going to help improve that multi-agency working. I guess the point is for statutory reviews, sometimes there are, really big recommendations made that do change national level. Just thinking about the child safeguarding review into the death of Sarah Sharif, which has recently been published. Yep. Looking a lot about elective home education, sort of feeding into the current legislation that's going through the houses around that, and actually that review's directly inputting into that. So I guess they can have those big kind of national implications, but equally they can have smaller changes that still have an impact. So I think it's that continuous improvement that's important.
And I think that's the thing, isn't it? You have got so many vulnerable children and adults out there that potentially almost don't have vulnerable status. They're not. When we think of vulnerable adults, we think of people with disabilities, things like that. You almost have that stereotypical image, I suppose, or an older adult or something like that. But actually, a vulnerable adult could be an 18-year-old that's turned 18 and all of a sudden is in a flat by themselves for the first time ever, and they've got trauma from their childhood of being, I know we don't particularly like the term foster child, but it's easier for most people to acknowledge. Looked after child, so they've got maybe 20 years or 18 years, of trauma behind them, and now they're an adult and they're in that transition services between children's and adult services, which, let's be honest, is an absolute mess in most local authorities anyway. And then their parent, as such, their foster parent, that may have been there, and I know they say that foster kids go from one to another, but some don't. Some have been with their foster families for a long time, but all of a sudden they're not there anymore. So all of their resiliences that they've built up have completely dissipated, and you've got a very traumatised young adult, let's be honest, child. Just because they turn 18 doesn't mean that they're not a child anymore. It's only a legal status. But then you've also got children like Sharif, that's educated other than in school. And I've got some small experience with home education. There is very few checks. I think in a year we had one person pop to the house and make sure that we were providing education, and that was it. They had no idea really what we were doing Monday to Friday, and not really any interest. So all of a sudden that child's resiliences aren't there either, and they're at risk.
Yeah.
But they're not the stereotype that we see on TVs and movies and things like that.
I think sadly sometimes you need something, because I guess that that'll always probably have been is that right? That there's that lack of oversight or anything happening. But I guess a lot of times people just accept that's just the way things are.
Yeah.
And sometimes it takes sort of a serious incident happening to kind of really, focus, shine a light, I guess, on a certain area and really unpick, actually, could we do this better? But you've always got to kind of balance that need to safeguard with, human rights. So, people have got right to private family life, autonomy, all those sorts of things. So there's always that tension that you've got, I guess, in safeguarding to get that balance right between those things. So it's definitely not easy.
No.
But I know we were going to talk about kind of thinking about safeguarding in the context of sort of private client work or...
Yeah, because you had a case, didn't you, where a deputy was involved?
Well, I guess sort of think about, I guess if we just think about like a scenario and where kind of, I guess our worlds collide a little bit. If we think about a case situation where there's a sort of a solicitor involved that's responsible for administering a person's estate. One of the beneficiaries of the estate is somebody, a family member who's got severe mental illness, substance misuse problems. We talked about vulnerability, care and support needs, but was kind of proven to have been exploited in their local community by unsavoury people in that community. Long track record of exploitation, police involvement, previous statutory safeguarding, all those sorts of things. So I guess within this situation that I was involved in, the solicitor was going to be releasing quite a significant sum of money to this person, but there was statutory safeguarding processes going on because there was essentially under the Care Act you have safeguarding inquiries for adults with care and support needs who are at risk of abuse, so section 42 inquiry, so a safeguarding investigation into that. How, to what extent should a private client solicitor or a deputy engage in sort of statutory safeguarding processes? In that situation, they did go to a strategy meeting. So lots of concerns were raised around this person's capacity, vulnerability to exploitation, also, quite high risk to self through drug use as well. But the solicitor kind of released the funds, essentially. This person took a big drug overdose and died. So I guess, working through that thinking about that from a safeguarding perspective, deputies and private client solicitors aren't statutory agencies.
Yeah.
So, to what extent have they got duties or responsibilities to engage in that? I don't know whether that would be something to kind of think about a little bit or talk through.
There's so much there. Firstly, I don't know. I'm trying to think how that would work with the deputies that we work with. I've not come across, can you assess this person's capacity to go and have a large amount of money to go and buy 10 grand worth of cocaine. I don't think we've done that yet. We have been asked to assess whether somebody has the capacity to understand smoking marijuana and things like that, because at the end of the day it's their decision, but they need to understand the consequences and risks, and that it's illegal and things like that. If I remember rightly, they certainly didn't have capacity. And I know there's that case recently where the patient, a P service user, had a large drug debt.
Yes.
And the deputy was stuck because the court protection said, well, actually you can't pay it, because if you do, you're essentially paying criminals. Mm-hmm. But if they didn't pay it, the chances are he was going to end up being abused, beaten up, let's be honest, or worse. So yeah, there is a fine line, isn't there, between what a professional attorney or a professional deputy can do without breaking the law. Mm-hmm. But then also there's that safeguarding. For that client, it's a perfect example, isn't it? There's this safeguarding concern. He's a vulnerable adult. If he's under the court protection, he's automatically a vulnerable adult. He's run up a drugs debt, and now they're threatening to beat or do worse, but the deputy can't.
Mm-hmm. Yeah, it's so difficult. And I guess one thing that if you work for a statutory agency, so when I worked in that NHS trust, there was a whole team of specialist safeguarding practitioners that people could go to for these complex cases for advice, to really unpick, what's the right thing to do in this situation, how do we balance all these tensions between kind of autonomy, human rights versus protection. We don't want to be too paternalistic, but we don't want people to come to harm, to help navigate that. But I guess if you're working, as a professional deputy or a solicitor, you don't necessarily have that same resource.
Potentially a small to medium-sized law firm is unlikely, I think, that you're going to have a specific safeguarding team there.
Yeah, so if we just think about this case that I'd sort of talked about, although private client solicitors or deputies, they're not sort of statutory partners in terms of public bodies, etc. I guess the care and support statutory guidance that accompanies the Care Act, particularly Chapter 14, which is all about safeguarding, is kind of really clear that everybody, all professionals, like safeguarding is everybody's responsibility. But even if we think about things like for solicitors, the SRA, they're quite clear that solicitors have got to act in the client's best interests, that they've got to, identify and respond to vulnerability in people that they work with. If we think about deputies, they're, bound by the Mental Capacity Act, and the OPG oversees all of that, and they've also got to do that acting in the client's best interests kind of things. So, and then also Section 6 and 7 of the Care Act, who talk about the duty to cooperate, which applies to public statutory partners, but also relevant others as well. So I guess solicitors and deputies, although they're not sort of statutory partners, they do still come under that sort of scope of, they're part of the safeguarding ecosystem. And if there's a situation where there's foreseeable high risk of harm, they kind of, there is an expectation that should be cooperating, engaging in safeguarding
and sharing
processes.
of information.
Yeah.
Because I think that's the biggest fear, isn't it? Is data protection.
Yeah.
It seems to have higher authority in people's minds than anything else. The amount of conversations we've had with other professionals where they're like, I can't share this, so it's under data protection. Like, well, actually, you can. And they're terrified of the Data Protection Act. We've had a question.
Cool.
But actually, under safeguarding, you can share information, can't you?
Yeah, there's lots of scope to share information. I think, especially if you're doing it for safeguarding reasons, actually there's loads of reasons why you can. So if we think about things like a serious crime's been committed, if we're thinking about this high risk of harm, so if it's a lower level, you've always got to think about proportionality. But actually, if the risk is high, if other people, including children, might be at risk, if whoever's the abuser in this situation or the perpetrators might be vulnerable, have care and support needs themselves, there's kind of lots of situations where actually you'd be justified to share information for the purposes of safeguarding. It's always got to be kind of necessary, proportionate, reasonable, if we think about the colder cop principles. But actually there is lots of scope to do that, and ultimately it's for the intentions of protecting a vulnerable person from harm. I think it's justified.
And the ICO, they're quite clear that they're not there as a punishment service. They're not there to you've sent an email with somebody's telephone number on, that's it, we're going to drop a £500,000 fine on you. They're there to try and support. The cases we see with the ICO or the public see are those huge cases where everyone's email and date of birth and 50,000 people have had their data breached. If you're turning around and saying to the ICO, look, I was concerned about this person, I was invited to this safeguarding meeting and I shared the least amount of information relevant, it's unlikely the ICO is going to come back and say, well, tough, you broke the rules, therefore there's a £500,000 fine here.
I think what's really helpful is when you document and when you come with this. So if we think about this case that I'd kind of talked about, there was, I guess, what would be good is to think about, obviously if solicitors got to administer an estate or distribute funds, they can't not do that just because there's a safeguarding concern. But I guess if they've been made aware of live safeguarding issues, they need to be thinking about, what what do I need to consider before I do this? Is there any legal justification for me to not distribute this money right now? So for example, is there a capacity concern for this individual? And if it's somebody that we know has got severe mental illness, that's previously been at risk of been exploited, might have drug alcohol concerns, actually there's probably reasonable grounds to doubt capacity. Should we hold off until the capacity assessment's been completed? Or do we need to think about get directions from the court of protection about how to handle this case? Or if there's coercion and control concerns, actually, you might be justified to delay it for that basis. But then if there's sort of live safeguarding concerns happening, what might be kind of reasonable in that situation is, even if the person's got capacity, there isn't kind of a deputy or appointee, that funds can be distributed in that way instead, etc. You can still kind of be part of that plan. I need to release these funds. We know that if that happens, this could escalate the risk of exploitation. It could escalate the drug use.
But then at least other services are aware of when and how that's going to happen.
How can we do this in a joined up, kind of working together kind of way? And I think that is going to, because I think people might be concerned around things like privilege, for example, but actually when there's safeguarding, you're just kind of saying, I need to do this, have I fully exhausted all the legal routes available, does this person have capacity or not? You can't just withhold funds just because there's a safeguarding concern, but actually you can release them in a way that the partnerships are, part of the plan of how to do it. And I think that's kind of like a good way to balance your duties to, for example, the estate or the beneficiaries as a solicitor, but also your responsibilities in terms of safeguarding as well, based on your regulator, but also what the legislation says as well. But it's difficult. It's very grey.
It is, because as you were saying it, I was thinking just having that money placed into that person's bank account, that sudden wealth, that in itself creates financial vulnerability, which could, you could have somebody that's got that is a MARAC meeting or something like that for domestic violence, let's say, but then all of a sudden that sudden wealth happens, and actually they become financially vulnerable for other reasons, and actually there's other people that then come in because this person all of a sudden has got £500,000 dumped into the bank account. So all of a sudden, scam artists and things like that, and it just makes their situation even worse. But if the deputies, the solicitors, attorneys are involved in those meetings and having those conversations, then those risks can at least be made aware and potentially reduced. You can't eliminate them, but they could be reduced because police and the NHS and everybody else is aware and is working with that person on it. We've got a question.
Okay. There's always a but.
But if a child is under Section 17 child in need with safeguarding concerns listed equally, shouldn't school already approach this category with automatic practices, i.e. monitoring around... Your phone's gone off for me. Around monitoring and that.
Is that the... Oh, hang on, just to make sure we get the whole question.
Around targeted concerns, this need not be expressed but must be implied, really.
It's chapter Section 17, safeguarding concerns. How do you approach this category of automatic practices? This must be implied, really. I'm not sure exactly what the bit about not be expressed must be implied. I guess with Section 17 child in need, we've got the legal, there's a legal framework for that in terms of the Children Act and working together to safeguard children. But there's the same expectation as simultaneously working. I guess, there's lots of children that are under child in need where there might be, there's going to be safeguarding concerns for a lot of those children. I guess, in terms of
any child that has any disabilities identified as a child in need aren't they?
Based on the local authorities can have thresholding for what comes under early help versus child in need, and I guess there's a lot of there's going to be concerns sometimes about neglect, abuse, exploitation. Think about criminal sexual exploitation. There's lots of children with safeguarding concerns that do sit under Section 17. I guess it's not going to tip into sort of the child protection arena unless those safeguarding concerns have been, deemed to be causing significant harm, and I guess because of...
I'm just thinking there'll be solicitors on there and others that don't know. So there's Team Around the Child, isn't the TAC meetings, which are low-level family support style work. Then if the concerns are higher, it goes to child in need, and then if it's serious concerns, then it's child protection, isn't it? Where there's a child protection plan and things like that. So child in need is that middle ground, I suppose, between this family just need a little bit of help and this child is in.
So I guess you have, it's called the continuum of need, but I guess for thinking about child safeguarding and just children's welfare of children, you have universal services, which is kind of at one end of the continuum. So those are services that all children should be able to access. There shouldn't be any gatekeeping or thresholding. So all children, regardless of level of need, should be able to access, GP, health visiting, libraries, children's centres, early years, that sort of thing. And then the next stage in the continuum would be early help. So TAC, Team Around the Child, is kind of a type of early help, I guess. It's not the only thing that can be delivered under early help. So that's kind of where, the level of need is higher than universal services. A family might need some lower level intervention, ideally at an earlier stage to prevent things from getting more difficult. So you can have that coordinated team around the child of several agencies, but sometimes a piece of intervention can be completed by one agency. If a child's kind of struggling with kind of low mood or anxiety or something like that, actually a piece of early intervention from a mental health trust's might just be what's needed. That's still a type of early help.
But generally the school's involved, aren't they? Family support work maybe.
If there's several agencies, it's best practice to coordinate intervention through a TAC. And then the next level is the first level of statutory intervention, so that's Section 17 of the Children's Act, child in need. So I guess this is where there's more complex difficulties that have been, potentially going on for longer. The impact's starting to be more significant. It's not always about safeguarding.
And involvement from those statutory services is a requirement, isn't it?
Well, it's still child in need still requires consent from parents for that process to happen. The only time you'd have intervention without consent would be child protection.
Right.
So that might be someone that's got really complex needs. So you might have someone that's got learning disabilities, mental health needs. There might be parental, difficulties as well. I guess it's the next step up, and then you have kind of the opposite end of the continuum is that child protection, but that's where I guess we're looking at a child's experiencing abuse and neglect and it's causing significant harm. And I guess what there is kind of breakdowns of what do we mean by significant, and people, things have tried to quantify that a little bit more, but I guess across all of that continuum, we still have that working together to safeguard children statutory guidance, which talks about the responsibilities of all those different agencies to work together, share information, coordinate.
And I think the question, the schools should be monitoring. They should be sharing information 100%. I'm not sure if we quite answered that question.
I don't know. I'm not sure quite what the question was getting at. But education is definitely, would be classed as a partner that's got a big role to play in.
I've been involved in TAC and child in need. Sure, I did child in need meetings so long ago, and generally the schools were always involved. They were one of the main actors as such, or the main stakeholders within the child. So they were always generally involved. Obviously, when it becomes to EOTUS education other than in school, that's almost impossible. But there is tutors and things like that I'd guess would be involved. I think if we were looking at child in need, there'd be questions about whether education other than in school is the right place, but we'll have to get EHCP people in to talk about that. But in a TAC meeting or a child in need meeting, generally the schools, the headmaster, headmistress, and the teachers, in my experience, was always involved, and it was them that were giving us the information of how that child was through the school day, sort of thing. So there's always monitoring and support.
There is. I think there's some tensions around education, not necessarily always being classed as a statutory partner, though. So just in terms of like a perceived hierarchy of agencies, and again, there's kind of lots of people campaigning for that they should be on that equal footing. So I think it's another watch this space around that. But so although that's kind of an
So
aside.
there's help from the local
practice,
authority and then...
in practice,
Terrible.
Education, as well as all the partners, would come under the scope of the statutory guidance in terms of expectations to work together.
I thought you were going to say we've got another question. Just going back to what you were saying about the adults and the financial vulnerability and safeguarding somebody. We had a case where a young man had inherited some money from his father. It was the entire estate. There was no other family, so it was all going to him. I think he was only 18 or 19 years old, and he'd ended up living with another family, where as soon as you walked in, you could see the undue influence on him. There was practice wisdom would say that there was concerns, but there was no evidence at all. They were lovely, and they were helping and supportive and kind and everything else. And you knew for a fact, as soon as that money hit his bank account, it would be transferred to their bank account, and he would never see a penny of it. Thankfully, we got to the point where he was able to appoint a professional attorney, and they were then able to set up trusts and manage it like that. But I mean, then there's cases. I know there's cases where our solicitors go out and they see those situations where they know that when that money gets paid into that person's bank account, it is going to be instantly transferred to somebody else's account, but the person's got capacity, and they're saying, yes, pay the money to me.
Yeah.
How do you deal with that?
So I love how you're calling it practice wisdom, because when I used to deliver safeguarding training, I always called it the professional ick. So yeah.
I think we were told we weren't allowed to use gut feeling.
No.
So it was practice wisdom.
Oh, so I'd be like, if it gives you the professional ick, then you need to kind of be curious and look at it, dig deeper.
The practice ick.
I mean, I guess if you think about kind of what the principles around things like making safeguarding personal, involving the person in the concern, I guess the first step should always be, talking to the person in that situation by themselves, trying to mitigate for any undue influence. I'm really worried that this is going to happen. Trying to get that person's view on that. What do they want the outcome to be? That's always going to be really good practice in terms of safeguarding. I think what's difficult, just if someone's got capacity, I guess, what I'm trying to get at here is you can't use them for, say, if you've got a safeguarding concern, the mental capacity acts, you can't really be used as a workaround to try, and avoid that. It's really difficult, and I know there's a couple of cases that we were going to try and squeeze in to talk about the kind of evidence that, but finding, talking to them about it. You need to be open with the person, transparent about your concerns, talk to them about what their options are. I guess the problem is as well, sort of statutory level threshold for safeguarding, the person's got to have care and support needs, be at risk of abuse and neglect, and be unable to protect themselves because of those care and support needs. So the situation you're talking about is somebody who's young, potentially naive, vulnerable, might have trauma, but that in itself isn't going to necessarily trigger that threshold for statutory safeguarding, and that is really difficult. But I guess it's kind of working with that person, coming up with solutions. What can we do to? It's almost like safety planning in advance, isn't it, for a scenario you think might happen. But I guess it's sort of showing you working this out for all of those things.
Now you've made me think maybe there is something there that the solicitors can do. Is there better safeguards that can be put in for within wills? I'm just thinking about my situation. If me and my wife were to pass away, well, actually, it'll go to my 18-year-old daughter and my 10-year-old son. Well, what do I put in place? What do I make sure in my will that if my daughter then ends up in that situation, that there is a safeguard there to stop that happening? So maybe it's considering the things that you hope never happen.
It's hard to get that balance, because you can't preempt every single thing that might happen. But I guess you've got to think about foreseeability of high risk. So, if there's a reasonably foreseeable high-risk outcome, like that case I talked about earlier with the person due to inherit a lot of money, I think in that scenario, I think there's lots of evidence that there's foreseeable high risk of harm. So what you do in response to that is probably going to be a high level of intervention, and that's going to be defensible versus that situation you were talking about where you're worried about it, but if there isn't a lack of capacity, they don't have care and support needs, the extent to which you can go without overreaching is going to be different, and it's like showing your workings out for what you do or don't do. I think is really important.
And the MCA there, it's not a hammer to be used to say, oh well, I'm using this to safeguard this person, so therefore I can stamp all over their rights, their autonomy, because I think this is. I'm protecting them, and it may be that you're protecting them, but that's the wrong legislation to use.
And just quickly, because I know we've only got a few minutes, I think that really segues in. There's been a court protection case that's just been published really recently about this. I think people, if they're interested, might be worth looking at. It's JW 2026.
Yes, you said about this.
And essentially, it was looking at somebody who was, was victim of coercive control from somebody else, domestic abuse. The court, they also had a borderline low IQ. The Court of Protection, they agreed lots of evidence of domestic abuse.
The low IQ wasn't an impairment of the mind or brain, was it? But that's what they've tried to sort of use as the impairment of the mind or brain, wasn't it?
And I think they were kind of quite clear in that case that there is domestic abuse, there's safeguarding, there's risk, but the Mental Capacity Act can't be used as a workaround for that. But then if you compare that to a case from 2021, which was BU, again, coercive control domestic abuse from partner, which was impacting on their ability to make decisions and weigh up, but that was built upon a foundation of this person had dementia as well, which did then satisfy stage 1. So kind of the difference, I think it's quite interesting to compare those cases to look at where that line sits between the two.
I'm not going to say that the judge was wrong. I think there was a mistake made there. I think trying to say that the low IQ was the impairment of the mind or brain was always going to be wrong, because just because somebody's more or less intelligent than the next person, of course that's not an impairment of the mind or brain. It's a silly argument. I think if you've suffered domestic violence, then that has an impact on you. It's as simple as that. That creates emotional and psychological issues. I think what needed to happen in cases like that is for a psychologist, somebody with experience in assessing mental capacity, to be able to go in and identify actually what's the right psychometric test that will evidence what the actual impairment is. Is it anxiety, depression? Is stress causing an impairment? Is general well-being? What is it? Because if there's domestic violence, there is always going to be an impairment of the mind or brain there, I think, because of the amount of... there was a report this week that said that people with frontal lobe difficulties, if they're under stress, very strangely, if you're under stress, most people in the short term, their focus becomes better. But people that have frontal lobe issues, stress actually does the exact opposite, and their thinking becomes impaired. So stress in itself for that person is going to have an impact on their cognition. And I think if you're undergoing domestic violence, the amount of emotional and physical damage that you're undergoing in that short period, there is going to be an impairment. It's just identifying how that is showing in you, because how it shows in you and how it shows in the next person can be two different things. And I think I think
I'd be cautious kind of saying, sorry.
Question.
We've had a question.
All right, quickly. I guess if you think about the fact that statistically, you need to put my teeth back in, 1 in 4 women and 1 in 6 men experience domestic abuse in their lifetime. We probably can't say that proportion of people, lack capacity in the framework of the Act. But what you're trying to get is that the impact of being a victim of high risk domestic abuse or like chronic domestic abuse over a long period of time, is going to cause, often trauma, and think about complex PTSD, which then, because it's causative nexus, isn't it? We need to link those two things. I think experienced domestic abuse, like the JW case, that in itself wasn't enough to satisfy. But if it's, the level of chronicity and impact that is then creating a sort of cognitive impairment, then it can. So like you say, how do we explore that thoroughly enough and be able to evidence that?
And it could be that there is an impairment and it's still not impacting on their capacity. It could be that there's an impairment and it is impacting on their capacity, but actually in 2 weeks' time, once they're out of that situation and everything else, that impairment is no longer there. An impairment doesn't have to be forever. We know that going out on a Saturday night and being smashed off your head on vodka is an impairment of the mind or brain. No,
imagine what you're talking about.
But actually, in certain situations, you wouldn't be able to make specific decisions. So I do wonder whether there was a little bit of more for that person that could have been done to identify actually what was the real impact of that domestic violence on them.
And I think some specialist capacity assessment being done by someone who's really specialised in that area, has got lots of sort of training experience of like trauma and presentations of trauma and the actual real cognitive impact of that. That's where that's going to really support that person, I guess.
We had one more question.
Continuation.
Yes, the CYPs needs read it. Sorry, I need my glasses. That's half of the problem.
These change gradually from tier 3 to at least tier 4. Fully requested day pass. Shown from memory, one-to-one provisions.